Hi again. Okay, short one. Well, I think. Fifth Amendment people, standing back, at the end of the day, the most directly relevant case is Wardias. There are some other cases, state cases, that give you some gloss, but in terms of Supreme Court law, that is law that the California Supreme Court must follow, pretty much we drill it down to Wardias. Really think about what makes the balancing work. Providers, you have the opinion below to help you. You have this wonderful factual distinction about confidential information, right? I would also argue that in the balance, the court should additionally consider that the SCA is balancing in Fourth Amendment like privacy rights. So that's part of the balance, right? So in fact, if anything, the confidential information here weighs it so much more towards non-disclosure. For real parties, right, I would focus more on what we're balancing is access or no access, right? And just the fundamental fairness. Part of what drives the Wardias decision, if you go back and look at that case, and it's not a long case, go back both sides and just read it one more time. It's your big case. Just read it one more time. You know, there's this fundamental unfairness of, you know, if a guy's got an alibi, it's horrible to think he wouldn't be able to bring that alibi up at trial just because he didn't disclose the name of the alibi to counsel beforehand. Similarly here, you know, it's really horrible to think that your clients can't put on a reasonable defense or just to defend themselves just because the information they need is on Facebook and not written in a letter or taken in a hard photograph that's sitting in someone's drawer. Because in those latter two cases, the letter and the hard photograph, you would have absolutely no problem getting them under 1326. So that really feels unfair. So really think about those issues and make sure that when you're making your larger points, that the core of your argument comes down to that. For my Sixth Amendment folks, so the confrontation clause is really, yes, we are making 3 Sixth Amendment arguments. The confrontation clause is the lion's share of this, correct? And it really boils down to Hammond. Are we going to overturn Hammond or not? So one tact, I know many of you on my Real Party side are focusing on, well, there's no possible way the court could have seen social media coming. So true. I think there's another tact that dovetails. So think back to the first time you read Hammond and you read the facts, and you probably thought something about the criminal defendant there like, wow, he's a dick, right? I mean, he's just a heinous, odious person, right? Who seems to just be torturing his foster child, even now in litigation. So it's reasonable to say something along the lines of, you know, the facts in Hammond are just so odious that that the Supreme Court overplayed its hand and not legislated and opined too broadly, right? So it's this 1-2 punch of the facts of Hammond led the court to potentially led the court to come on to hold more broadly. And that combined with the fact that they couldn't have foreseen, you know, how social media was about to take over everyone's lives. There's just something so unique about the case of Hammond, right? That doesn't, and you understand why the court comes down so hard in Hammond because of the facts, because you have this foster father who wants to go through his foster child's records and then ends up admitting to everything on the stand when all through pretrial he was claiming he did nothing. And he has no reasons to go through, he has no articulable reasons to go through the young lady's psychiatric records, whereas here you can clearly identify what you're looking for. You have a theory of the case and you're specifically only looking for those things, right? And yes, your requests are broad, but you know why you're going in. And that is different than Hammond. Okay, so, but the other side, I think you just say, look, the core of Hammond, right, is that this is how you deal with confidential information. The confidentialness puts a bar at the pretrial stage, and there's really nothing in the confrontation clause at the pretrial stage that can overcome confidentiality, whether that confidentiality is a privilege under state code like 1014 in Hammond, or is a statutorily mandated confidentiality via federal statute like in the SCA. So that's really your focus on the provider side. Is there's just the other side can't articulate any reason why the underpinnings of Hammond, that is, this is the way we deal with confidential information in the pretrial stage, nothing's changed about that. So yes, the internet has changed the world, but the way that courts should deal with confidential information hasn't. Plus, then you also have the public policy issue of, I mean, heavens, how would the courts even deal with this much information? So really step back and think about that. Think about how could you present those arguments to the reader. But you do need to be clear, real parties. You're gonna lose the confrontation clause argument if you can't get the court to roll back Hammond at least to its facts, right? You really can't. Because although the Supreme Court may not have definitively said that the confrontation clause offers no pretrial access to discovery, the California courts have, and that's Hammond, and it's a problem. So you do need to be very clear about distinguishing the case as to the reasons for the discovery, right? It's not very good faith in Hammond. He doesn't really have a good faith need. You do, right? That's one. But two, there's also this, in making the holding, the court's very wrapped up in the heinousness of the Hammond facts and doesn't appear to have an eye to the broader context. And your tact is essentially, Hammond's gotten out of control and this court needs to rein it back in, right? And that's a pretty reasonable ask, right? Okay, do watch your phrasing though, because you don't want to phrase to the court you're trying to get to roll something back that they totally messed it up in the first instance. Do watch how you present that. Make the error sound very understandable, but it's one that they need to correct. Does that make sense? Just sort of being political with the court that you're writing to. All right, hope those thoughts help. But really, do take a moment, just sit down, read the opinion below one last time, read your one case that matters so much to you, that would be Wardius and Hammond, and just, are you making all the arguments you need to be making to get the court to do what you need them to do? And any argument, the farther an argument gets from that core, the less important it is, right? I'm not saying there aren't ancillary issues that are important. There are, but the farther from those core arguments, the less important they are. And is your brief bringing what's the most important to the fore? All right, thanks so much.